committee meeting to order. First bill, we're waiting on a printing for a committee sub for 2180, so we'll come back to that one. We'll skip over and go to Senate Bill number 2433. This is Senator Walter Michelle's bill, who is, I believe he's in another meeting currently. But Lucian, I believe you're going to come up and present the bill for us. Check green light on.
In fact, it's been so long, there wasn't a button that you had to turn on to get the microphone to work. Senate Bill 2043 is a bill of relatively limited application that clarifies provisions in the Public Utilities Act. And by way of background, and Mr. Chairman, if I'm giving more information than you would like, you just let me know if I'm going on too long.
Go ahead.
The men in my family, half of them became preachers and half of them became lawyers, and all of us talk too much. So this is a bill of relatively limited application having to do with the Public Utilities Act. If a entity has a certificate of public convenience and necessity issued by the Public Service Commission, they have monopoly power within their certificated area to provide the type of service for which they are certificated. They also have a duty to provide service inside of that certificated area. And the trigger for becoming a utility is if you sell water, electricity, gas to the public. So there's a little bit of ambiguity as to whether or not a homeowners association providing water to its own residents would become a utility operating illegally without a certificate of public convenience and necessity. The bill you have before you is specifically limited to any neighborhood that is in a municipality with greater than 100,000 people that has had issues under the Clean Water Act, which is obviously a reference to the city of Jackson, and that secondly was constructed prior to, I believe it's 1970 in Senator Michelle's bill, has access to a private well system and that continues to operate for a private user and that was subsequently annexed by the city of Jackson. There is one neighborhood that I know qualifies under this definition, and that is the Country Club of Jackson neighborhood in Northeast Jackson. When the Country Club neighborhood was originally developed, it was outside of municipal boundaries. And it was constructed with a well system that served both the clubhouse and was intended to also serve the entire neighborhood. And there are adequate tanks there to serve the neighborhood. There is an argument to be made that a homeowners association wouldn't be selling water to the public if they took that well system and began selling water only to residents of the neighborhood. For instance, I could drill a well at my personal property for my personal use without becoming a utility. The purpose of this bill is simply to clarify that the Country Club of Jackson Homeowners Association or a similarly situated neighborhood that happens to be in a city that has water problems and has access to a currently functioning well system originally designed for the neighborhood would be able to do so without becoming a public utility. That is the purpose of the act, Mr. Chairman, and I'm happy to answer any questions that members of the committee may have.
Okay. Are there any questions from the committee? All right. Seeing none, for a motion. Motion is title sufficient to pass. All those in favor signify by saying aye. All opposed? The ayes have it.
Thank you, Mr. Chairman.
All right. Next bill we'll be doing is Senate Bill 2451. This deals with the disposition of income tax that currently is charged to student debt relief. If the feds forgive student loan debt, Mississippi is one of very few states that tax it as income. Most states do not recognize it as income and do not tax it. Therefore, Mississippi, this bill would put Mississippi in that category where we do not tax as income student loan forgiveness. That is an explanation of the bill. Are there any questions? Seeing Senator McDaniel for a question. Sure.
Thank you, Mr. Chairman. I'm a bit torn. I need to understand first, it's any and all student loan forgiveness. I'm assuming that language would encompass President Biden's executive order. And I guess my question is the executive order law, or has a court declared it not to be law yet? I'm not sure. Has there been a ruling on that somewhere?
I'm not aware of it. I think, go ahead, Senator Blunt.
Thank you, Mr. Chairman. Thank you, Senator McDaniel. That's a good question. I asked the same question prior to filing the bill, and I'm told that it is not law. It's subject to litigation, and oral arguments are scheduled in the Supreme Court for February 28th.
Right. I'm curious if, I don't know if you have any interest in this, a friendly amendment, just pointing out that the discharge or forgiveness, if it's a congressional act, then that would be applicable. That would clear that issue up once and for all.
I would say if it's legal, if it's found to be legal by the Supreme Court, and I don't know what they'll do, but if it's legal, then we should extend that forgiveness if it's legal. And the Supreme Court says that it's not, then it'll be a matter for Congress to deal with.
When do they anticipate a ruling? Do we know?
I do not. Again, I know that the date of oral arguments is set for February 28th, and so I would, by the end of June.
Okay. All right. Thank you.
Thank you.
Are there any further questions? All right. Seeing none for a motion. Motion is title sufficient to pass. All those in favor signify by saying aye. Aye. All opposed? The ayes have it. The bill will be reported out. Next bill, Senator Boyd, Senate Bill number 2696. Senator Boyd here. There she is. Okay. Didn't see you up there behind Joel.
Thank you, Mr. Chairman. This bill, what it does is during our, we were looking at the Women, Children's and Families Committee this year, there was a provision that kind of struck us. We wanted to look at adoption credits. Presently, the state gives a $5,000 adoption credit to anybody that adopts a child. What we asked the Senate to do right here is to extend that amount if they adopt a child from Mississippi, particularly from the foster care system. We are asking y'all to extend that to $7,500, specifically if they adopt a child that's resides within the state of Mississippi. And that's really just to encourage people to really look at adopting. We have so many children that are available for adoption. And this is really just to extend it and really give people just to kind of say, hey, look at the children that we have already here that need good homes. So that's the essence of it. And I'll be happy to take questions.
Senator Blackman for a question.
Yes, thank you, Mr. Chairman. Do we know how many people presently take advantage of this?
Senator Blackman, I am trying to get those numbers and I hope to have those numbers, but I have had a little bit of difficulty getting that number. Oh, presently take advantage of this. Senator Blackman, I didn't bring the numbers, but I'll be happy to get those numbers to you. And then I'm also trying to get a better perspective on how many adoptions we had statewide last year with children that were already from Mississippi.
And do we know how much money will be coming from the state treasury as a result of?
We are trying to get additional numbers on that. So those are one of the things that we're really trying to get. We've got some estimates, but I've had some questions about those numbers. So I've gone back to them to ask to give me better data on that.
So before this is taken up on the floor, we have those numbers?
Yes, Senator Blackman, I do plan to have those numbers.
Thank you. Thank you, Mr. Chairman.
Ma'am, any other questions? Senator McMahon for a question.
Yes, sir. Senator Boyd. Senator Boyd, thanks for your work on this. This will be for any adoption, whether it's public or private, as far as, because, we've got the Pentecostals operate one of the largest, and I think their only adoption, their only children's home in Tupelo, and I want to be sure that those children would qualify.
Absolutely. It's for any child that's adopted within the state of Mississippi that resides in the state of Mississippi.
Yeah, thank you. Thank you for your work and heart on this.
All right. Any other questions? Senator Boyd for motion.
Mr. Chairman, ask for title sufficient do pass.
Motion is title sufficient do pass. All those in favor signify by saying aye. All opposed? The ayes have it. Next bill is Senate Bill 2703. Senator Simmons, you're recognized to explain the bill.
Thank you, Mr. Chairman. Members of the Senate, we've actually passed this bill in this committee and also passed it on the floor and sent it to the House several times. This bill basically allows the waiver of the driver permit, learner's permit, or intermediate license permit fee for an applicant who is in the custody of Child Protective Services. That's all the bill does. And I'm happy to answer any questions.
See any questions?
Title sufficient do pass, Mr. Chairman.
All right, motion is title sufficient to pass. All those in favor signify by saying aye. All opposed? The ayes have it. Senate Bill 2851. Senator Thompson, you recognized to explain the bill.
Thank you, Mr. Chairman. Senate Bill 2851 is an update and revision of an existing loan program and R&D program that was first enacted in 2007. To just run through the bill quickly, in section 1 is primarily a name change from the Research and Development Program to Innovate Mississippi, which is who is administering this program. Turning through to section 2, or I'm sorry, at the end of section 1, on lines 86 to 87, increases the maximum amount of assistance that a business may receive under the program from $200,000 to $250,000. Section 2, beginning on line 128, changes the name of the program from New Technology Business Program to a Proof of Concept Loan Program. Section or lines 181 through 183 increases the amount of the loan available to each business from $10,000 to $25,000. And lastly, on lines 279 through 287 incorporates some clawback language for any businesses who are recipients of a grant or a loan under this program who false or knowingly, or who submit false or knowingly incorrect information. That's an explanation of the bill, and happy to ask and entertain any questions.
It's the explanation of the bill you heard. Are there any questions? Senator Blackman for a question.
Thank you, Mr. Chairman. Presently, do we know how many businesses are taking advantage of this program?
Yes, ma'am. So the existing program has invested in 42 companies for a total of 3.4 million, that those companies went on to raise 15.5 million and now employ 137 people.
And the existing program is a loan program as well. They have to repay the monies.
The existing program is a loan program, but there's also, it's changed, there's a grant and a loan under this existing language. So the grant would not be repaid.
Okay, so how much is grant and how much, I think I saw 25,000. Is that for the loan or is that the grant?
The increase from 200,000 to 250,000 is the grant assistance that's on lines 85 through 87. The loan, the $10,000 loan doesn't change.
Okay, so people,
I'm sorry, the grant's up to 10,000. The loan is increased from 20 to 25. I had it backwards.
the grant is 10,000,
Grant's 10, loan's 25. I apologize.
but they can, so is it per employee or something? Because you say up to 250,000 in the aggregate.
I don't believe it's by employee. I don't think there, I don't know, it's not, I don't think it's, I don't get the impression it's like an MDA grant program where they have, so much for each employee or each job created. I don't think it's that. It's more for these technologically based in investors or companies.
And can you give an example?
So there's a Mississippi State students had a startup company called Glow that that started up underneath here, and they're now valued at nearly $20 million. There's another one, a skin consultant that received a $100,000 award from here. And let's see, there's another one here. Shovel Solutions received $100,000 under the seed fund.
And so you say we've spent how many millions, and we've gotten 137 jobs, I think you said?
The existing program has invested in 42 companies for a total of $3.4 million invested. And those companies went on to raise 15.5 million and now employ 137 people.
And were those people employed prior to utilization of this fund? Or were these jobs created?
Well, it would be jobs created because these are startup companies. These aren't companies that are in existence that are applying for these grants. They're startup companies. So those would be new jobs.
Thank you, Mr. Chairman.
Thank you. Senator Horn for a question.
Thank you, Mr. Chairman. Yes, for a question. Senator Thompson, can you describe the proof of concept grant program?
So my understanding is that the proof of concept grant program, that is a change in language from what they were calling the new technology business program, but the actual language in the existing statute remains the same. I think it's more of a change in name.
So it's not a new program that's being stood up.
It's not a new program that's being stood up. So if you look there on lines 130 to 135, the only change or the only what's deleted there in line 132 is the new technology business program, and it's being replaced with the proof of concept loan program. But the remainder of that language stays the same.
Thank you. And is the source of this seed fund the SSBCI program from Treasury?
I think that my understanding is that they expect an appropriation later in the session.
An appropriation from the legislature?
Yes, sir.
Okay. But do you know if any SSBCI funds are being utilized in this program?
I don't know the answer to that. Mr. Dent is here and may be able to answer that question. No,
Thank you. Thank you, Mr. Chairman.
Thank you. Seeing no more questions for a motion.
Title sufficient to pass.
Motion is title sufficient to pass. All those in favor signify by saying aye. All opposed? The ayes have it. We'll go back to Senate Bill 2180. The proposed committee substitute was just handed out to you. Senator Kaufman, you're recognized to explain the bill.
Thank you, Mr. Chairman. Had a couple places in my district that approached me about wanting to be added to this qualified resort status bill that we have done several times. One of those is the city of Florence. I got a resolution from the mayor and signed by all the aldermen requesting that the area along Highway 49 and then also Highway 469, which is really what their main street is there in Florence, requesting that area to be included as a qualified resort area. And the other one was the Simpson County Country Club. Again, I got a resolution signed by all the board members requesting that the country club be added as a resort area. In Simpson County, this is really the go-to place there in the county. A lot of wedding receptions, a lot of county-wide parties there, and a lot of different county events are held there. So that's pretty much what this bill is all about. Also, there's a committee sub, and if you'll look down, let's see, it's in line 463. we added section, line 51 there. It says the governing authorities and municipality described in whole or in part in all those cities. The city of Florence just wants to be added into that so that they can specify the hours of operation of facilities that are offering alcoholic beverages for sale. So that's the committee sub.
I think that's line 565 on the committee sub.
Yeah, 565. 565 is committee sub, that's right. And I'd also like to add a reverse repealer to this bill too, Mr. Chairman.
Well, thank you for doing that. This bill's become like the tag bill. It's become an omnibus resort status bill. So you heard the description of the bill. The amendment is to add a reverse repealer to take it to conference. There's several other resort status bills that people have filed across the state. So you've heard the amendment. Are there any questions on the amendment? Seeing none, all in favor say aye. All opposed? Ayes have it. Bill's amended. Are there any further questions on the bill? Seeing none, Senator, for a motion.
Title sufficient, do pass, committee sub.
Motion is title sufficient to pass committee sub. All those in favor signify by saying aye. All opposed? The ayes have it. I'll be reported out. Next bill is Senate Bill 2862. Senator Barnett, you're recognized.
Thank you, Mr. Chairman. Senate Bill 2862 is basically a bill similar to what the legislature did in 2018 with the Airbus up in Columbus. And basically what it did for the Airbus is that before Airbus could only make one part of that helicopter and then go to another place out of state and assemble it so that the individuals or the company that was buying it could take receipt upon it without having to pay tax on it twice. Well, the legislature came back and decided that Airbus could assemble the whole helicopter there in Columbus. The parties that was buying it could come there and buy it, test it out, and fly it out of the state of Mississippi and only have to pay taxes at the destination, at the state of destination. That's what we're trying to do here on other manufactured goods where the individual can come into Mississippi, train on that piece of equipment that they're buying, and then be able to drive it to another state where they will only be having to pay the taxes on it there. Similar to the same thing that was done with Airbus in 2018. And what this does is that it allows these companies to bring in these individuals to the state of Mississippi, showcase their talents, train them there. Then these individuals, of course, rent rooms and the whole nine yards. So it's just a good thing for the state of Mississippi to be able to allow this. And it helps our manufacturers become more competitive in an age now where competition is very important. So that's basically an explanation of the bill, and I'm open to any questions.
Okay. I think it's on line 449, for those looking at the bill. Are there any questions? Senator Boyd for a question.
Do we know how many businesses this will affect?
I know there's at least 2 in my district, and I'm sure that there's 1 or 2 on the coast that this will affect as well. So I'm sure there's industry across the state that this will affect, but it's a great thing because when we allowed it to happen for Airbus, then it only increased the amount of product that Airbus was able to sell from being able to do this.
Thank you.
All right. Any other questions? Seeing none for a motion, Senator.
Title sufficient, do pass.
Motion is title sufficient to pass. All those in favor signify by saying aye. All opposed? The ayes have it. That bill will be reported out. Last bill, House Bill 401, Senator Sparks.
Thank you, Mr. Chairman. House Bill 401 is a bill that looks very similar to the bill we passed last year out of committee and out of this chamber that addresses the auto dealership franchise laws in the state of Mississippi. The language in 63-1775, which is the first statute that is addressed, is primarily the same. The new information begins in section 5, which addresses that if you're going to sell new automobiles in the state of Mississippi from a dealership, that you follow the franchise laws of the state of Mississippi. These laws were enacted in July of 1970. So for 53 years almost, this has been the process. There is not anything in this bill that would prevent the direct sales of a new motor vehicle from a manufacturer to a customer via the internet and things of that nature. But if they want to have storefronts, dealerships in the state of Mississippi, they have to follow the existing law. Cannot be a subsidiary wholly or partially owned by a manufacturer. We, basically are looking at it that there is a actual franchise relationship. The second statute that is impacted by that is 6317-109, which gives exceptions. I would say the first statute are the rules that we're asking everybody to abide by. And the exceptions to that would be in section 6 that you see on roughly line 204. These are transitional situations. Sometimes a dealership may be taken over by a manufacturer because of a bankruptcy for a very limited period of time, just to have a transitional period. And we wanted to make sure that carve out was in fact available. And then also that there is an exception for a dealership that has been put in this state that was continuously licensed since August 1st, 2021. So there is one dealership that fits that criteria, and this legislation does not affect that dealership's opportunity to operate. That's a brief explanation of the bill. Mr. Chairman, I'd yield any questions.
Senator England, you have a question?
Yes, a question, Mr. Chairman.
You're recognized.
Thank you. Senator Sparks, you mentioned that, or I believe you mentioned that it is currently unlawful for a manufacturer to have a wholly owned subsidiary operating a dealership and selling their new vehicles in this state. Did I understand you correct?
I think the franchise laws that have been on the book since 1970 have been followed in that capacity, and I think we're clear to most everyone. There was a question that arose a couple of years ago. Now, I think it would be where a manufacturer requested a manufacturer's license as well as a dealer's license. The Motor Vehicle Commission, who gives those licenses, in fact, asked the Attorney General's office for an opinion, and the Attorney General's office opinion said they did not see a prohibition. Therefore, this legislation clarifies what has been followed for 52 years prior.
So to understand, so you mentioned this Attorney General's opinion. The Attorney General's office looked at this statute that we currently have in place. And is it correct that they found that there is currently no prohibition on a manufacturer having a wholly owned subsidiary operating in this state as a dealership? Is that what the Attorney General found, that there was no exception to that?
I believe that's a fair recitation of the opinion rendered by the Attorney General, yes.
Okay, so with that being said, it seems that it's currently not lawful or not believed lawful, at least by our Attorney General's office, who researched this matter pretty thoroughly, from my understanding, that it's not unlawful for a manufacturer of a vehicle to open a wholly owned subsidiary company as a dealership. Is that right?
That is what I believe the Attorney General's opinion states. Yes, that's correct.
Okay, is there some disagreement to that?
Me personally, or?
Yeah, you personally, or if you're aware of any disagreement with that Attorney General's opinion, that's what I'm asking.
Yeah, I disagree with it. I think that it is not inside the spirit or the letter of the law, but now the Attorney General's opinion has a right to offer an opinion. Of course, that is couched by the fact that it's named an opinion. We write law. So, the law we believe was clear. There is an opinion on that law that says we don't see a prohibition. And so this bill actually establishes that prohibition that some of us believe already existed. But yes, it does clarify the position.
Okay, and I do agree. We certainly do write law, and it seems that we're writing law now to try to close out in industry here, but I'll get back to that maybe a little bit later. Are you aware of any lawsuits that have been filed in this matter? If this is something that we're alleging, and as you mentioned when you were presenting the bill a moment ago, that it's believed that this is unlawful. Are there any lawsuits that you know of?
I'm not aware of any existing lawsuits.
Okay, and we did discuss this bill last year, so this is a matter that's been before us for at least one calendar year. Would you agree with that?
Yes.
Okay, do you have any idea why there haven't been any lawsuits filed?
I certainly don't know the inner workings of everyone involved with this. I know that this legislation's been filed again. And to my knowledge, there's no legislation that's been filed by anyone who feels differently. And the same legislation has come back. So I do believe that the industry has understood for 52 years what this was. And when the request was made, the Motor Vehicle Commission obviously thought it was not proper. Otherwise, they would have issued a license. But they asked for an AG's opinion, which is very studious on their part. And the company that made the double license request immediately went out and filed for an LLC in the state of Mississippi, which, you know, I have an opinion, just like the AG's office has an opinion. And I think that opinion is that they intended to circumvent what had been the practice and understanding of the law for 52 years. But I do not know of any lawsuits, and I do not know of any other legislation other than I dropped a bill on this side that's very similar to the House bill that has passed and come to us in this committee.
And you mentioned earlier that we passed a similar bill to this out of this committee last year, and I want to address that for a moment because we did pass an amended bill that's not directly similar to what we had before us. And since this committee has precedent of looking at this issue and passing out a bill with new language in it, I'm going to ask that I be allowed to offer an amendment at the proper time that will, in fact, give us the exact same language that we passed out of this committee last year, since that seems to be what we're trying to do here.
I think that was to the chair.
That was the chair. Thank you.
At the appropriate time. Are there any other questions? Seeing none. Oh, I'm sorry, Senator Blackman for a question.
Thank you, Mr. Chairman. I recall last year Senator Fillingane raising a question about if we allowed this entity that I guess grandfather and that entity in, could they open multiple locations? And so under this, they would be able to open multiple locations?
No, Senator, I do know that was discussed. As I understand this legislation, they would be limited to that one location that is currently in existence.
Okay, thank you.
Thank you.
Thank you, Senator. Any other questions? Senator England, you have an amendment?
Thank you, Mr. Chair. Yes, my amendment that I would present, if you look at lines 225 through 229, that is where this bill that we have before us is different from the one we passed last year. It says that the ownership, operation, or control of not more than one motor vehicle dealership location within the state. I propose that we amend that to say no more than 7 motor vehicle dealership locations within this state, which is the exact bill that we passed out of this committee after much debate last year. And I'm happy to speak on the amendment and to take any questions on the amendment if there are any, but that is my amendment.
Okay. Well, you're free to speak on it if you'd like.
Yes. So I obviously have very much difficulty with this bill and understanding why we even have it before us. But since it is before us, and since we're going to look at our precedent from last year and try to get these with 7, I will say specifically that last year, we were the only state in the country that was trying to close our market down to these electric vehicle manufacturers for being able to do as they've done here. To our direct east, the state of Alabama is a closed state. To the west, Louisiana is a closed state. And Mississippi, if we limit ourselves to just one motor vehicle dealership, we are going to miss out on a tremendous opportunity if we don't pass the same bill we passed last year to have additional dealerships open up in the state of Mississippi. And just to put that into perspective, if an electric vehicle manufacturer were to put a dealership anywhere on our Mississippi Gulf Coast, it would be the only dealership between the cities of Tampa, Florida, and Houston, Texas. And we're going to tell them no if we're going to limit them to the one motor vehicle dealership location within this state. And I think that would be an extreme, extremely terrible move on our part when we can see economic growth from this. So again, I think I'm keeping my amendment very simple. I'm just asking that we pass the same thing we passed last year, which is to allow 7 motor vehicle dealership locations, which, as Chairman Fillingham mentioned appropriately last year, seems like a nice heavenly number for us to look at when we're looking at how many we do. So if there has to be a number, I think 7 was a pretty proper number.
Thank you, Senator. Any questions?
Not a question, maybe a statement.
Speak on the amendment.
Please speak on the amendment.
You're recognized.
I would first of all defend Senator Fillingham's statement is it was biblical. That's I think the 7 is a biblical credit. I would oppose the amendment. There's a couple of things. One, this bill does not limit dealerships by electric vehicles in the state of Mississippi. They are welcome to open as many dealerships. So we shouldn't cap them at 7. They can open 27 if they'd like. They just have to follow the franchise laws of the state of Mississippi, of which our legacy manufacturers have followed and all manufacturers have followed. To pretend that the propulsion system of your vehicle makes it not a motor vehicle is a little disingenuous. We have electric vehicles that want a carve out, that want a second set of rules that are different from the current rules. I would say in a business market, one of the important things to draw industry is that you have laws that are understandable and you stand behind those laws, that they're consistent, that they can count on that their investments can be counted on. And in this particular case, there is no pushback against electric vehicles. There's no pushback against the number of dealerships. We're just saying that you have to follow the franchise laws. What these companies want to do is come to the state of Mississippi and say, we will put up a storefront where we so desire. We will put up a dealership where we desire. We will go down to the mall and throw up a kiosk where we so desire without any guidance from the franchise laws of the state of Mississippi. That's a little bit too far. I think also that the dealership model has worked in the state of Mississippi. If there is a desire to change the dealership model, again, I welcome a bill to be brought forward that we can discuss. But this particular situation is the spirit of the bill that we had last year. If the bill last year allowed for more than one, as to the question from Senator Blackman, I certainly don't mean to mislead that. This bill allows for the one that is currently in existence. But I would respectfully ask that you vote against the amendment and that we move forward to clarify what the understanding has been of the franchise law for over 50 years.
Senator Bryan, for a question or a comment?
I have an amendment to the amendment at the appropriate time.
Okay.
Strike 7 and insert 666.
You heard the amendment. Would you like to speak against it?
I would oppose the amendment on numerous grounds.
Senator England, do you have any comment on the amendment to your amendment? Okay.
I think we can take a vote on the amendment.
All in favor?
Aye.
All opposed? All right, the noes barely carry.
Are we
Back
back
on the
on the-
original amendment?
Yes, if I may just close with the
Sure,
rebuttal.
you're recognized.
We keep.
Senator Fillingham has a question real quick. Senator England. Go ahead, Senator Fillingham.
Thank you, Mr. Chairman, and thank you, Senator England. I'm curious, under your amendment, if the legacy dealers, strike that, if everyone other than legacy dealers would like to open a dealership, I think the answer you gave was, what exactly could they do so or not do so?
Yes, that was a question that I had, and it appears that based on the Attorney General and on the law that we have before us, it's on our books now, making us an open state to this type of sales model, that yes, this is it's completely legal for them to do so.
Now, are you aware of any of these EV dealers that are not legacy type dealers opening dealerships in any of the other states?
I am aware of them having dealers in other states, and I understand we're dealing with kind of a new innovative technology and new innovative sales model that is present in other states, but certainly not in Alabama and Louisiana, where they are closed from having those having that ability. Whereas here in Mississippi, under our current law, unless we adopt a law in front of us, they are allowed to come and establish that here in this state.
Well, it's my understanding that these factory-owned or company-owned dealerships are located in some other states, but they don't have any of these locally owned dealers selling their vehicles in any other state. Is that your understanding?
Yes, I'm quite certain that I have, when I drive around to take a trip, there are both traditional dealerships and electronic vehicle dealerships that do coexist in this country, believe it or not, and they're not, don't seem to be shutting down.
So is it one thing, would you agree with me to say that you're free to partner with a local dealer and open as many of these dealerships as you would like to, but at the same time, the reality is that's not their business model, and Tesla's not going to partner with a locally owned dealer, nor is Rivian or Lucent or any of the others that are strictly EV automobile manufacturers. Is that correct?
That's correct. That does seem to be their sales model. And I certainly wouldn't want to stand in their way of entering new contracts and being able to discuss language with other individuals. That is certainly their prerogative. And I certainly wouldn't want our government to tell them they can't enter into contracts, much like these current franchises that we have that are doing things and following a different sales model are able to contract with the manufacturer.
Is it your further agreement with the statement that it's extremely unconservative to start telling the businesses how they ought to operate within our state, especially if they've never operated that way in any other state in the country? And would you agree that, if you say, sure, come and partner, they could certainly do that under our current laws, but the reality is, since they aren't going to do that, all we're doing is turning business and investment away from the state of Mississippi when we could stand to benefit in a significant way?
Senator Philligain, I would say that this certainly seems to not be a conservative bill that we have in front of us. And I certainly think it limits both consumers and manufacturers in this state from reacting to the consumer market and doing as they have done before. And I would take that one step further and say that when we're seeking out new economic development in this state, as we always should do, to try to bring high-paying jobs and bring new businesses into this state, sometimes the difference between us landing a new business or a new market in one of our new industrial parks, such as in the Golden Triangle region or anywhere along those lines, anywhere in this state, sometimes it's a small difference that keeps us from landing those. And if we close down our market, Senator Philligain, I'm worried that we may be sending a message to these manufacturers and the suppliers that supply parts and batteries for these new cars, which may be looking to locate in like the Hattiesburg area or somewhere along those lines. We're telling them, thanks for looking at us, but we're not going to let you sell your cars here. We're going to close our market down. And just to show that I'm not just making this up, there was a $3.6 billion new investment in the state of Nevada, an open state, for a battery manufacturer. That's $3.6 billion that they landed by being an open state. And I sure would hate for us to close our market and miss out on those opportunities for Mississippians and for new Mississippians to come here and have electronic vehicles, which, by the way, certainly seem to be popular with the younger generation. And we hear brain drain a lot in this building. And I think that we're taking a wrong step in that as well. And I know I've answered more than you asked, but I think that I hope that gives you an idea of what could happen and why this is not a conservative piece of legislation.
I appreciate your answer to my question. Just maybe one or two more. Is it your understanding that Tesla is currently shopping around on the Mississippi Gulf Coast looking to place a dealership there? And if this legislation passes and becomes law, then that will become unlawful. More to the point, there are some other places in North Mississippi, DeSoto County and Tupelo, where they're also looking that this would also foreclose any investment in those areas as well.
I certainly have heard that. I have specifically heard that about the Mississippi Gulf Coast, where we always like to be open for new jobs and for new technologies and to try to attract new businesses. And I wouldn't, if I was here and had one of my other colleagues tell me that they sure hope to get one of these in one of their locations in one of their parts of the state, I certainly wouldn't want to stand in their way of having that possibility, which is the reason for at least this amendment that we have before us to bring out the exact same bill that we sent to the floor last session.
Thank you. Thank you, Mr. Chairman, for your indulgence.
Thank you, Senator. Senator England, did you have anything you want to follow up on?
I would just like to mention one more thing about my amendment, Mr. Chairman. I understand this is a difficult topic for us because we all have people that are calling us and telling us that this is maybe the worst piece of legislation they've seen for their industry. And they want to limit this sales model to just one because they were able to, again, follow our law and put that one dealership here. And we're seeking to do that. It's difficult for us to tell those folks, listen, we get what you're saying, but it's just bad policy for us to do that. And this could have implications way further down the line for the state of Mississippi. And we could miss out on a lot of opportunities. And we do care for you, but we're here to pass laws that are good policy to help us attract these new industries. And that's what I was saying. I would ask you please to consider supporting my amendment.
All right. Seeing no further questions or comments on the amendment, if you're in favor, vote aye. If you're opposed, vote no. All in favor, say aye. Aye. All opposed, say no. No. The noes have it. You want?
Could I ask for division? Yes, Mr. Chairman.
Senator England for a question?
Yes, for an amendment, actually.
Another amendment? Okay.
Yes, I do have another amendment.
Go ahead.
Mr. Chairman, I know we're all busy today and I have last year an amendment passed the House after the Utah model. And I would like for us to at least see us do that, but there's a lot of discussion involved with that amendment.
Mm-hmm.
And it is, in fact, it's not perfect. It's probably not loved by all parties involved, but it is at least a discussion and a compromise position possibly. And so that we can discuss that further, I would ask that we add a reverse repealer to this bill so that we can talk about this House bill that we have in front of us now that's not subject to a deadline, and just give us a little bit more time to discuss this and make sure that we're making a good decision. So it'll be for a reverse repealer. That's all I'm asking that's this amendment.
You've heard the amendment. Any questions, Senator Sparks? For comment?
Speak on the amendment. at the
Sure.
proper time.
You can speak.
I would oppose the amendment. Once again, here we are a year later. Nothing has been presented in the position that seems to be discussed here. We have a bill in front of us that has in fact passed the House. It passed the Senate last year overwhelmingly. And it is something that if in the future people want to bring legislation forward, we'll be glad to look at it and see where we are. But I think these discussions will probably be had again at length if this bill goes to the floor. I don't want to belabor it, but this bill is something that establishes one set of rules. And at the end of the day, what is being asked is two sets of rules. There's a lot of hypothesis about closing the state with some level of investment. The fact is, if we want to talk about conservatism, it's not conservative to have a $7,500 rebate on your vehicle. We want to talk about conservatism. It's not conservative to be one of the most subsidized companies on planet Earth. Now, that's not part of this bill, but somehow we're discussing that. The fact of the matter is the bill has been in front of us. It continues to be in front of us. And a reverse repealer in this case, I don't think benefits the situation. I think people that want to bring forth legislation to address the emerging markets can do so with their own legislation this year. I haven't seen it yet, or certainly they can bring it next year, but I would oppose reverse repealer.
A question.
You have a question?
Yes,
Senator Blackman for a question.
thank you, Mr. Chairman. Now, you mentioned that this came before us last year in your opposition to this reverse repealer.
Yeah, yes, Senator.
But from my, I guess, listening to this, this is not the bill that we voted on last year. Is that correct?
This issue came before us last year, and this bill is very similar to what we had last year. I don't think any of the arguments or the metrics have changed from last year.
The England amendment was the bill that this body, this finance committee passed, and the Senate subsequently passed, was it not?
As I recall, there was an amendment added in the finance, which was Senator Fillingame's amendment, was added in committee. The bill passed out on the floor. That amendment was removed. Senator England offered a study committee amendment, which ultimately failed on the floor. And then we passed the language that is very similar to this, but which I think may have the one issue that you brought up earlier. Yes, Senator.
Yes, ma'am.
Yes, ma'am. I said, yes, Senator, I apologize. That yes, ma'am is fine too.
Thank you.
Thank you, senators. Senator England, you had a comment?
Yes, I just want to close on my amendment, if I may.
Sure.
Just to address Senator Sparks' concerns about, maybe there being some government help with these entities. I'm certainly surprised to hear that didn't exist for any of our other automobile manufacturers previously. When we talk about subsidized markets, I don't know why we're going to pretend like that only exists for electronic vehicles and not pretend that that existed for other larger manufacturers, particularly back around 2008 in that period of time. But I just wanted to say that in case that was important to anyone else to know that, these subsidies from the federal government may go both ways, oddly enough. So we can talk about that. But look, I just want to make the point to address another, obviously another hang up for Senator Sparks is that where is the other bill? Well, oddly enough, if you're operating within the law currently, you really don't need another bill. And we don't have that before us because these automobile manufacturers are operating within our laws that exist. We're seeking to shut them out right now. We're closing the market down to them. That's why there's not another bill. There was a bill that passed the House last year that was it was similar language than what Utah did. I still don't think it's great because I think we ought to be open and allow these people here. But look, we can talk about that. We can talk about this Utah amendment that did pass the House last year before it was brought back for them for further debate. This went to the deadline last year. And I'm not aware of any conversations that other people may have had with these electronic vehicle markets and manufacturers, but I've certainly talked to them, and I don't think they've been talked to, and we act like, oh, well, you had plenty of time to discuss this with us. Well, my study committee bill failed last year, so we didn't get to really talk about it the way I wanted to talk about it. And then here we are in week 4 with a House bill in front of us that we're speeding through the system before we have much time to talk about it. And you know what? That should give us pause. We're not up here. This legislative process takes a while. It's supposed to take a while. We don't want to get a bad bill out on the floor and pass it just because We have one market that's scared of, that what may happen if we allow for innovation in Mississippi. Let's slow the process down. Let's add this reverse repealer and give us another chance to talk about it. We can bring it to the floor with a reverse repealer. We can take the reverse repealer out on the floor if we want to. But let's at least prolong this conversation and make sure that we're getting this right. And I would just repeat, $3.6 billion investment in Nevada and open state for a battery company. And I imagine that would look very, very good in Northeast Mississippi as far as the job market is concerned. And I would hate for us to miss out on that because, again, it's little small things like that that will tell a battery company that may see what Tennessee has or Alabama or Louisiana. They may be looking at what they have, and they may say, you know what, they all look pretty similar, but why not Mississippi? Well, Mississippi went out of their way to rush a bill through their legislature to close the market down for this new system, and we didn't appreciate that. So why don't we locate somewhere else? And that's going to happen. We know it's going to happen. So let's please vote on this reverse repealer. Let's amend this bill right now. Let's talk about it longer. We don't have to have this next week. Nobody's going to close down within the next 2 months. Let's talk about it. Ask for your support for this reverse repealer on this bill. Thank you.
All right. Seeing no other questions or comments on the amendment, if you're in favor, vote aye. All those in favor say aye. Aye. All opposed? No. Noes have it. Are there any questions on the bill? Senator Sparks for a motion.
Title sufficient, do pass.
The motion is title sufficient, do pass. All those in favor signify by saying aye.
Aye.
All opposed? The ayes have it. That bill will be reported out. Motion to rise and report. All those in favor say aye. All opposed? The ayes have it.